Hello, my name is Anna Maria Hubert, and today I will be providing an introduction on the governance of Marine Cloud Brightening, including a discussion of the application of existing instruments, norms, and processes to these emerging climate technologies, as well as a discussion of what potentially lies ahead regarding governance. So now let's talk about what we mean when we talk about governance. Governance is an elusive and comprehensive concept that evades precise definition. However, it generally refers to interactions amongst norms, structures, and processes that determine how power and responsibilities are exercised, how decisions are taken, and how citizens and stakeholders have their say. Governance is multi-layered and takes into account a wide range of actors, including governments, governmental and non-governmental organizations, the private sector, and citizens. Benchmarks of good environmental governance include legitimacy, transparency, accountability, inclusiveness, fairness, integration across different levels and organizations, capability, and adaptability. And these are frequently referred to in the literature on SRM and its governance and are potentially applicable to the governance of Marine Cloud Brightening specifically. And so here we can reference institutional definitions which pretty much track the ideas that I've discussed here. So the topic of Marine Cloud Brightening and its governance potentially transects with many different subject areas of law and policy, such as environmental law, human rights law, global peace and security, international development, food security, and the law of the sea. And as you'll see from this particular presentation, we're not starting from a blank slate. There are many existing legal concepts, jurisdictional considerations, and norms with potential applicability to Marine Cloud Brightening activities. At the same time, one may point to several gaps in the existing governance landscape for Marine Cloud Brightening at both the domestic and international levels. And to the extent that existing regimes are found wanting, one may ask a number of specific governance questions in relation to future governance of Marine Cloud Brightening, including what should be the aims and objectives of governance, who should promote and adopt governance measures, at what level and in which forum, at whom should governance be directed, and what should be the legal form of the governance response. So let's now turn to some of the legal frameworks that may potentially apply to Marine Cloud Brightening measures. International and domestic law currently reflect a patchwork of instruments and norms with relevance to Marine Cloud Brightening. Let's turn to first general norms of international law. And there are several general principles and norms of customary international law that are potentially applicable to the governance of Marine Cloud Brightening. These include the duty to cooperate, the duty to prevent transboundary environmental harm, the precautionary principle, transboundary environmental impact assessment, and the duty to notify and consult. In the interest of time, I will focus my attention on the duty to prevent transboundary environmental harm and the precautionary principle. As noted in previous presentation, there is some potential for undesirable side effects from Marine Cloud Brightening, including the potential for changes to participation patterns and amounts, as well as interannual variability in precipitation. There is a possibility, for example, that a state undertaking Marine Cloud Brightening activities may cause transboundary harm to another state or to global areas such as the high seas that fall within the global commons. States have a customary law obligation to ensure that activities within their jurisdiction and control do not cause significant damage to the environment of other states or to areas beyond national jurisdiction. As a corollary of this no harm rule, the principle of prevention requires that a state in a transboundary context use all means at its disposal in order to avoid activities which will take place in its territory or in any area under its jurisdiction, causing significant damage to the environment of another state or to the global commons. This obligation may be invoked where the risk of harm is significant and is to be assessed on factual and objective criteria of harm, depending on the circumstances of the case. The customary rule on the prevention of transboundary harm entails both procedural and substantive elements. Procedural obligations that run with this duty include the requirement to conduct an environmental impact assessment, as well as collateral obligations of consultation and negotiation and information sharing. Substantively, the principle constitutes an obligation of due diligence, which is similar to a negligence standard. This generally requires that states avoid, minimize, and reduce the risk of harm, taking all best possible efforts. Due diligence applies to the activities of the state directly, as well as to the activities of private operators within a state's jurisdiction and control. This dimension of the obligation is significant in the context of marine cloud brightening, given the concern that some climate engineering measures, such as MCB, may be carried out by private individuals, such as scientists or corporations. Given the universal application of the no harm rule to all states with the status of customary international law, the rule on the prevention of transboundary harm is an important piece in the governance of marine cloud brightening, providing a kind of floor for its regulation generally at the international level. The precautionary principle. In its most conservative formulation, as enshrined in Article 15 of the Rio Declaration shown here, the precautionary principle stands for the idea that where there are threats of serious or irreversible damage, lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures to prevent environmental degradation. The precautionary principle, or the precautionary approach, offers a more recent addition to the body of international environmental law aimed at adjusting the insufficiencies of the regimes of prevention discussed just previously. The fundamental distinction between these concepts lies in the extent of the evidence of harm of an activity. The preventive principle applies where risks are known and can be proven scientifically, whereas the precautionary principle runs in advance of prevention, calling for action to protect the environment before sufficient scientific evidence of harm can be fully furnished. As such, given the large uncertainties that surround and will likely to continue to surround marine cloud brightening as it is scaled up, the precautionary principle is clearly relevant to the development and use of marine cloud brightening, since it applies where the potential risk of an activity can be identified, often using traditional risk assessment methods, but where scientific information is insufficient to fully demonstrate or quantify the risk or to prove a cause and effect relationship between the activity and possible adverse effects. One issue is that the legal status of the precautionary principle under customary international law remains uncertain and is probably emerging at best. However, this may be mitigated by the fact that it can be rolled into the general obligation of due diligence under the principle to prevent transboundary harm. So we'll now look at relevant treaty regimes that may apply to marine cloud brightening. And unfortunately, it's impossible to be exhaustive in this analysis, as there are many instruments that may potentially apply to these emerging technologies. However, I will focus on the main ones. And these are the Law of the Sea, International Climate Law, and the Convention on Biological Diversity. So the Law of the Sea, and first, the 1982 UN Convention on the Law of the Sea. The preamble of the 1982 UN Convention on the Law of the Sea reflects the intention of its drafters to settle in a spirit of mutual understanding and cooperation all issues relating to the law of the sea. Though it was negotiated and adopted at a time when climate change was not yet part of the international agenda, the Convention constitutes a living treaty that may adapt to new challenges relating to the uses of the oceans and their resources, potentially covering marine cloud brightening in the future. Several parts of the Law of the Sea Convention may be relevant to the development and use of marine cloud brightening, including provisions on the operation of vessels, platforms, and structures at sea, conservation and use of marine living resources, including fish, protection and preservation of the marine environment, including the regime on marine pollution, marine scientific research and scientific research installations or equipment, development and transfer of marine technology, as well as due regard obligations with respect to other legitimate uses of the seas and oceans, where there's a potential conflict between marine cloud brightening and other activities such as shipping, as well as compulsory and binding dispute settlement procedures. State sovereignty, sovereign rights, and jurisdiction over marine cloud brightening would vary depending on the maritime zone in which the activity takes place. In general, the jurisdiction and rights of the coastal state diminish by zone moving seaward from the coastline. Therefore, it's important to ask where the marine cloud brightening activity is taking place in order to determine which state has jurisdiction and what legal rules apply. The Law of the Sea Convention also regulates matters functionally, and perhaps the most important provisions in the Convention in this regard relate to the development and use of marine cloud brightening as they relate to the protection and preservation of marine environment in Part 12 of the Law of the Sea Convention. The term marine environment is undefined in the Convention, raising the question of the extent to which the provisions of Part 12 cover activities that involve the modification of atmospheric conditions that take place over ocean surface waters. However, some of the adverse effects of marine cloud brightening fall within the scope of Part 12. Though there is limited knowledge on this point, marine cloud brightening activities might introduce changes to marine ecosystems through changes in clouds and cloud cover by reducing the amount of sunlight that reaches the ocean surface waters. In this regard, Article 192 of the Law of the Sea Convention sets out the fundamental obligations of states to protect and preserve the marine environment. The content of Article 192 is further elaborated in Article 194 of the Convention on measures to prevent, reduce, and control pollution of the marine environment. Pollution of the marine environment is defined at the beginning of the Convention in Article 114 as the introduction directly or indirectly of substances or energy resulting in harm to the marine environment. The phrasing of this definition permits an evolutionary interpretation, allowing for new threats to the marine environment to be read into the Law of the Sea Convention over time, including those possibly related to emerging marine cloud brightening technologies. Marine cloud brightening would not entail an introduction of energy, but rather involves a reduction of energy into the ocean's surface waters. So it is unclear whether it would directly fall within the scope of the treaty and Part 12 in particular in this regard. Article 194.1 addresses prevention of marine pollution. This due diligence obligation requires that states, individually or jointly as appropriate, take all measures consistent with the Convention that are necessary to protect, reduce, and control pollution of the marine environment from any source. This obligation is Janus faced with respect to the potential application of climate engineering measures, including marine cloud brightening, conducted in the marine environment. On the one hand, marine cloud brightening may be regarded as the necessary measure to control pollution of the marine environment from greenhouse warming, which itself constitutes introduced energy and falls within the definition of marine pollution. For example, marine cloud brightening is being explored as a measure to protect rapidly bleaching and degrading coral reefs due to climate warming, and thus could be construed as a measure to prevent, reduce, and control pollution in the form of warming oceans from the greenhouse effect. On the other hand, marine cloud brightening itself may constitute a form of marine pollution. For example, one question is whether the use of sodium chloride or sea salts as the emitted particles in marine cloud brightening delivery would result in increased salt deposition, possibly affecting salinity of the ocean surface in areas in and surrounding those in which marine cloud brightening is deployed. This would amount to an introduction of a substance possibly resulting in harm to the marine environment. Given the large scientific uncertainties, it is important to note in this regard that given its time of negotiation and adoption, the Law of the Sea Convention does not expressly incorporate the precautionary principle into the text. And so a lack of scientific evidence about the harms posed by marine cloud brightening activities may pose an issue to ensuring legal accountability for damage to marine ecosystems, given the need for a foreseeable, probable, and significant risk. However, as I mentioned earlier, it is possible that precaution could be imposed as an element of due diligence. So let's now talk about another instrument that may on the face of it not apply to SRM methods, and that is the London Protocol Amendment on Marine Geoengineering. So in 2013, after assessing the legal and scientific issues related to public controversies surrounding ocean fertilization, the contracting parties to the London Convention and London Protocol adopted by consensus a new amendment on the regulation of marine geoengineering. Marine geoengineering is defined in the amendment as, quote, a deliberate intervention in the marine environment to manipulate natural processes, including to counteract anthropogenic climate change and or its impacts, and that have the potential to result in deleterious effects, especially where those effects may be widespread, long-lasting, or severe. As a legal term of art, this definition constitutes one of the first conceptualizations of geoengineering to be enshrined in binding international law, though not yet in force. The amendment adopts a so-called positive listing approach, which allows for the regulation of new marine geoengineering measures on an ongoing basis. Under this approach, only those activities listed in a new annex are subject to regulation. And currently, only ocean fertilization is listed in the annex. On the face of it, this definition might not be applicable to SRM. However, it does potentially cover marine cloud brightening delivery methods that use ocean fertilization for enhancing marine clouds. Some scientists have suggested that the use of dimethyl sulfide produced by ocean fertilization of ocean biota as a source for cloud condensation nuclei could be used as a way of putting or operationalizing marine cloud brightening, though others have raised doubts about the efficacy of this approach. The current listing for ocean fertilization in Annex 4 permits a scheme that allows for legitimate scientific research on ocean fertilization to take place, but prohibits all other ocean fertilization activities. It's important to note that the London Protocol Amendment is not yet in force, with only 6 contracting parties having deposited their instruments of acceptance to date. And this situation also reflects the limits on relying on treaty-based approaches for regulating climate engineering methods internationally going forward. So let's now turn to international climate law, starting with the 1992 UN Framework Convention on Climate Change. This convention was negotiated and adopted in need of the recognition to establish measures to address anthropogenic climate change. The convention is a framework convention that provides the legal and institutional basis for further evolution of the international climate regime, most recently with the adoption and coming into force of the 2015 Paris Agreement. The ultimate objective of the UNF C2GLearn is to establish, quote, the stabilization of greenhouse gas concentrations in the atmosphere at a level that would prevent dangerous anthropogenic interference with the climate system. Building on the UFCCC's overarching objective to prevent anthropogenic climate change, Article 2.1 of the Paris Agreement sets forth the goal of holding the increase in global average temperature to well below 2 degrees above pre-industrial levels and to pursue efforts to limit the temperature increase to 1.5 degrees above pre-industrial levels. This provision is often discussed as a basis for not only requiring or mandating that we use carbon dioxide removal in order to stay below these temperature thresholds, but also possibly the argument that we need to deploy research and deploy SRM in the future, given the slow progress that we've made on decarbonization globally. The pathway for achieving this long-term temperature goal, however, is set out in Article 4.1 of the Paris Agreement. This provision establishes the collective aim that parties reach a global peaking of greenhouse gas emissions as soon as possible and that they achieve a balance between anthropogenic emissions by sources and removals by sinks of greenhouse gases in the second half of this century. As such, the Paris Agreement clearly specifies mitigation and the possibility of CDR as a means for achieving the long-term temperature goal in Article 2.1. While SRM measures, including marine cloud brightening, are not prohibited, the focus in the Paris Agreement is on mitigation as a means for achieving the long-term temperature goal. And this suggests that states parties, at least now, could not rely on SRM as a means to displace their mitigation obligations under the agreement. So let's now turn to the third area, which relates to the conservation of biological diversity, and in particular, the 1992 UN Convention on the Conservation of Biological Diversity. This agreement establishes the relevant international regime for the conservation of biological diversity, the sustainable use of its components, as well as the fair and equitable sharing of the benefits arising out of the utilization of genetic resources. Since 2008, states parties have adopted a series of COP decisions on climate-related geoengineering. And I'll turn to the text now. The first of these is COP Decision 1033, which in paragraph 8W invites parties to ensure in line and consistent with previous decisions on ocean fertilization and biodiversity and climate change that in the absence of science-based, global, transparent, and effective control and regulatory mechanisms for geoengineering, and in accordance with a precautionary approach in Article 14 on environmental assessment in the Convention, that no climate-related geoengineering activities that may affect biodiversity take place unless there is or until there is an adequate scientific basis on which to justify those activities. Though the chapeau of this paragraph adopts a highly attenuated language, in essence, this decision calls upon states to exercise due diligence over climate engineering activities within their jurisdiction and control, which may affect biodiversity. Decision 1033 carves out an exception for scientific research on climate engineering where such research is scientifically justified, subject to specific conditions. Adding to this decision is a more recent decision from 2006 on climate-related geoengineering. In addition to reaffirming past COP decisions, this decision underscores the relevance of international climate regime to climate engineering and the importance of addressing the root cause of the problem through emissions reductions and removals, stating that climate change should primarily be addressed by reducing anthropogenic emissions by sources and by increasing removals by sinks of greenhouse gases under the UNFCCC. The decision further notes that more transdisciplinary research and sharing of knowledge on climate engineering are needed specifying particular terms for research. In addition to international law, we may turn to domestic law in analyzing what existing legal frameworks may be applicable. So as we see in this image, marine cloud brightening may have impacts on the land within the borders of a particular country and impact, for example, business interests. Here we have a hotel that's getting rained on consistently. And so the question relates to what national laws and frameworks might be potentially applicable. And so some of these may include marine protection legislation, clean water legislation, endangered species regulation, environmental impact assessment, weather modification legislation, as well as a number of obligations in tort law, as we call it, in common law countries such as negligence, private nuisance, and public nuisance. It's also important to note that there are a number of soft law instruments that are potentially applicable, which have largely been devised by academics in anticipation of climate engineering research and other activities taking place. These would also potentially provide guidance on marine cloud brightening and its research and development. In addition to treaty bodies, several international institutions have mandates relevant to the governance of marine cloud brightening. These include the UN General Assembly, the UN Environment Programme, or UNEP, the International Law Commission, the UN Educational, Scientific, and Cultural Organization, or UNESCO, the Intergovernmental Oceanographic Commission, or UNESCO IOC, the World Meteorological Organization, or the WMO, as well as the Intergovernmental Panel on Climate Change, the IPCC. Though time does not permit me to discuss all of these international organizations, I will highlight a few important points relevant to the governance of marine cloud brightening. So the UN Environment Programme, or UNEP, is the key body dedicated to global environmental matters within the UN system. It enjoys the universal membership of all UN member states and has a strong scientific function and mandate, while also providing policy guidance and extending to key issues, which extends to key issues including climate change, disasters, conflicts, and environmental governance. UNEP has already directly engaged with the issue of climate engineering through its main governing body, the UN Environment Assembly, or UNEA. At UNEA's fourth annual meeting in March 2019, Switzerland, backed by other countries, tabled a resolution on geoengineering and its governance for consideration of other members. The operative part of the resolution requested that the executive director of UNEP prepare an assessment of geoengineering technologies, in particular CDR and SRM, encompassing a number of terms for their study. Over the course of the meeting, the resolution went through several rounds of revision, as is typical in these negotiating situations. However, the revised resolution was ultimately withdrawn for lack of agreement, including due to a disagreement over the application or incorporation of the precautionary principle in the operative body of the text. The International Law Commission was established by the UN General Assembly in 1947 to initiate studies and make recommendations for the purpose of encouraging the progressive development of international law and its codification. A recent program of work on the protection of the atmosphere led to the ILC examining international law issues related to geoengineering, as it's termed there, and the legal limits on the intentional modification of the atmosphere. Now at the stage of integrating comments by government, Draft Guideline 7 on the international or intentional large-scale modification of the atmosphere currently recommends that activities aimed at intentional large-scale modification of the atmosphere should be conducted with prudence and caution, subject to any applicable rules of international law. The third organization I'd like to highlight is the World Meteorological Organization, or the WMO. This is a specialized agency of the UN charged with facilitating and promoting international cooperation and coordination of the state and behavior of the Earth's atmosphere, its interaction with land and oceans, the weather and climate it produces, and the resulting distribution of water resources. In view of this relevant mandate, the WMO's program of work could potentially be expanded to include SRM and Marine Cloud Brightening in particular. Specifically, the WMO's Expert Committee on Weather Modification seeks to encourage strategic research on purposeful augmentation of precipitation, reduction of hail damage, dispersion of fog, and other types of cloud and storm modifications by cloud seeding, and providing guidance about best practices for operational projects. Though weather modification is conceptually distinct from climate engineering, the WMO is potentially well positioned to play a role, for example, in promoting cooperation and coordination of scientific research, building scientific and technical capacity, and reviewing criteria for marine cloud brightening research, including economic, social, ecological, and legal implications, and offering guidelines and infrastructure for the planning and monitoring of in situ experiments on marine cloud brightening. So this is a big topic to cover in 30 minutes in any great detail. However, I will end with a few concluding thoughts. Existing international law remains largely silent on the regulation of marine cloud brightening, at least expressly. However, many instruments, norms, and processes are relevant. The current legal and institutional landscape relevant to marine cloud brightening presents a complex patchwork of overlapping norms and institutional mandates. For this reason, fragmentation remains a concern, suggesting the need for mechanisms that promote greater coordination, coherence, and efficiency at the international level and between states and other intergovernmental bodies. At the same time, the literature points to significant gaps in existing regimes, suggesting the need for further cooperation at the international level to promote effective, legitimate, and fair governance of these emerging climate technologies. Finally, research and development raises a unique set of issues under domestic and international law, and this raises a question of the need for bespoke governance of research for marine cloud brightening. Thank you very much for your attention, and I look forward to our discussion later.